Welcome to the session on all you wanted to know about enforceability of employment contracts. I took up this topic because this is a matter of interest for all the persons engaged in drafting the employment contracts and executions and enforceability and all that. So I thought I should share relevant materials on this, and then I made an attempt to present this before you all. I will just give a brief introduction. We enter into contract day-to-day life. It's a matter of our common way of life. For instance, we get into a taxi, we hire a taxi, and we take the service and pay the taxi charges. That's a contract. We go to a shop and we pick up an item and we purchase the item, and then he sells it to us, we accept it, we pay the consideration. That's a contract. So like that, we engage into a lot of contracts like this. These are all called implied contracts. It's not in writing, but it has got the same force of contracts or even agreements. Now let us come to our corporate sector. In corporate sector, we also engage people either on express contracts or implied contracts. For instance, we hire casual laborers on daily basis. We take them and then we take the work. They work as agreed between us, and then we pay the salary for the day and discharge. So that's a contract. And similarly, we engage people on contractual basis. We enter into contract and discharge them and pay the consideration. That's an implied contract. And then we hire people on permanent basis. We conduct interviews and then issue them the letter of appointments. In the letter of appointment, we specify the probation period if it is there, and conditions there too, saying that if the probation period is satisfactory, then you will be confirmed in the services of the company on the terms and conditions which is there in the said appointment letter. In the letter of appointment also, many times, most of the time, we also use the clause like how the appointment can be terminated by either party by giving either 1 month notice or 3 months notice, or 3 months notice or 1 month salary in lieu of notice, etc. we mentioned. See, these are again, this is an implied contract. So this is how we also engage people, day-to-day life like this. We enter into implied or even express contracts. Now, the thing is that I would like to focus on the various types of contract we really enter in the corporate. We enter into a lot of contracts. For instance, in the corporate, employee agreements we enter into, and non-disclosure agreements we enter into, and the non-solicitation agreements we enter into, and non-compete agreements we have. The agreement of deputation, trial and serve for a stipulated period, that also we do. And agreement not to violate intellectual property and the secrecy of the company, that also we enter into. And agreement for restraining from taking up assignment or job if any competitor or any organization engaged in similar business, we also enter into. All these type of contracts we enter into while taking the people and executing it. Now the question is, how far these contracts are enforceable under the Indian Contract Act 1982 is a question. Now the important thing is we need to examine and then see how best these contracts can be executed under the Indian Contract 1982. See, let us focus on some enforcement of contract in the court of law for any breach of contracts. Contract is with the company for a specific number of years for having deputed for training, and otherwise the company will claim liquidated damages. And contract to serve the company for a specified number of years and also not to take up any employment for a specific period with any organization engaged in similar business or trade. And not to disclose any confidential and trade secrets, cost of product or system manufacturing or anything connected with that during the course of what we acquired during the course of his employment, not to disclose and then if he violates suitable damages or any other legal action we may take. This is normally this is the clause what we incorporate in the agreements. And similarly, non-solicitations. We also insert clauses saying that non-solicitations against employment or even canvassing for the similar products, getting in touch in solicitation, either the selling of the product, not selling the product, all these things are restricted, we incorporate in settlement agreement to say that this shall be taken into paying liquidated damage for this. Then theft or misuse of intellectual property. If it does so, we are going to levy liquidated damage. These are the terms of clauses where we incorporate in our employment agreements at the time of joining or at the time of deputation of training, and we do that and we enter into agreements. The questions are again, as I said already, enforceability. How far it holds good in law, how far it is going to enforce, but we need to closely examine it. Now, the thing is that let me take you through some important definitions of under the Contract Act, because they are very relevant that one must understand about the enforceability. First of all, what do we mean by a contract under Section 2H of the Indian Contract Act 1982? It's a very simple definition. It says that contract is nothing but an agreement which is enforceable in law. That's what it says. So these are the two important elements of a contract. Agreement is something fine, but whether the contents of the agreement or any provisions of the agreement is enforceable in law, or the clauses or the contents are opposed to any law is the question. So if it is enforceable under law, then it's a contract. Take the example, simple example of you. We issue a letter of appointment to a person. Then in the contract we say that if you want to terminate, you want to resign and terminate this agreement, you need to give 3 months notice or 3 months salary of notice. No, that is enforceable, because if he fails to pay the notice period and goes away, that thing is definitely enforceable under law, because it doesn't restrain anybody, anything, it's not against law. So it is a valid contract. So like there is an example I gave you. So the important elements are whether the contents or the subject is enforceable in law, then only it's called a contract. Now I will take you to Section 23. This is very important. This Section 23 says that if the agreement is lawful unless it is prohibited law, or is such a nature that if permitted would defeat the provisions of any law, or is fraudulent, or it implies or involves an injury to the person or property of another. The court regards this as immoral or opposed to public policy. So here please note the word opposed to public policy. This is a very, very important word from the point of view of interpretation of the enforceability of law. This is a very, very important question, important sentence. So please bear it in mind, opposed to public policy. Now we have to decide what is opposed to public policy has been enunciated by various courts right from 1874 itself. This has been debated by several laws and several theories have come. I will just take you through in short while. Then I will take you to Section 27. The agreement in restraint of trade is void. If you enter into any agreement restraining anyone from exercising his lawful profession, trade or business of any kind, to that extent it is void. So this is an extremely important clause to be noted. Just keep it in mind. This will help us for understanding the further discussions on this topic. Now I will take it to Section 73. Now the question of claiming damages. Section 73 of the Contract Act clearly says that the pre-agreed estimated compensations agreed to in the settlement without force, bias or with consent they agreed, this compensation can be claimed by the person who has been affected by the breach of contract. So this gives a approval to say that any predetermined amount in the contract can be enforced by a court of law. This is one clause. Now I will take it to section 74. This again you should read with section 73 in the previous slide what I gave you. Here it says compensation of breach of contract where penalty is stipulated for. Penalty. Now for instance, we generally say that if you don't serve the company for a period of 2 years, if you leave in between, you shall pay a liquid damages of 2 lakhs or 5 lakhs or anything. In law, it is called a penalty. In Indian law, it is called penalty because it is an act of terrorism in the sense that you are threatening him. If you don't work for me for 2 years, I am going to pay you. You have to pay me the amount, 2 lakhs or 7 lakhs. So this is the court has in section 73, 74 says it can be claimed, but a reasonable compensation only is possible. It means that you can't claim, you can't get the same compensation what you have put up in the agreement. A reasonable compensation depending on the circumstance is payable. This is exactly what it says. Now here please note the word a reasonable compensation not exceeding the amount so named in the contract. So bear this in mind, then we will go further. So keep in mind and remember these sections what I briefed just now for foregoing discussions. For ready reference I can give section 2H, that is contract, points of valid contract. Number 27, section 27, agreement of restraint of trade, profession or business. 73, compensation for breach of contract. Section 74, breach of contract where penalty is proposed. So these 4 sections, just bear it in mind in our foregoing discussions, that's going to help you. The words opposed to public policy have been debated in number of cases by various courts, including Supreme Court of India. Here there are 2 things. One is restrictive covenant, that is during employment and outside employment. They say that during employment you shall not disclose and the secret, blah, blah, everything. And restrictive thing is you shall not take up any employment after you leave the company and then do the business in the competitor company. That's a restrictive covenant. Negative covenant again is that you shall not disclose certain issues, certain matters, etc., etc. And then you should never do, even when you're outside the employment, you should not indulge in disclosing your secrets and confidential information. That's the negative covenant. Then third thing is the amount of damage stipulated in terrorism, that is penal in nature. If it is unconscionable, extravagant and absolutely out of proportion to the injury cause, is opposed to public policy. So now here, what do you mean by opposed to public policy is restrictive covenant during employment or outside employment. Negative covenant again is during employment and outside the employment, and the amount of damage is stipulated in terrorism, that is reasonably very high and harsh. These are the 3 basic parameters what they call is opposed to public policy. Now I will take you certain cases, then you will be able to appreciate how the things are being interpreted. Then here, when you go further, the application of enforceability in terms of contract is bifurcated into 2 parts. One is that enforceability of the terms of the contract, whatever enter into in various things, while in service. Then enforceability of the same terms after leaving the service. There are 2 things. The courts have admittedly held in favor that anything which is during employment is enforceable in law, because as an employee he is bound by all terms and conditions he is expected to follow, and you can enforce it under any circumstance. There is no hindrance about it. Now the question comes, enforceability of the same terms of contract after leaving the service. This is a very, very difficult question. Now let us see. First, let us take up the contracts concerning non-compete agreements. Non-compete agreement, normally what we say, is that not to disclose, divulge trade secrets or information or any confidential information, documents, etc. to anyone outside the company while in service, and also after leaving the service to any competitor or anyone who is engaged in similar business, etc. This is one clause we normally insert. Second clause normally what we insert is that not to take up employment with anyone who is a competitor or anyone who is engaged in similar business for a specified period. Sometimes we specify 2 years, sometimes we may specify 8 years, or sometimes we may 10 years, whatever we do, we specify. This is what is called non-compete agreements. Now, non-compete agreements, how it has been held valid in law, let's examine it. Now, it's a very, very settled position, as I said you already. Such contracts enforced within employment is held valid. All the courts have endorsed, yes, definitely you can enforce because he is in employment, yes, you can do it. And you can also claim damages in case of breach of contract, of terms of contract, if it arises. But such contracts' enforceability outside the employment have been subjected to legal scrutiny and interpretations, rendering such contract as void and not enforceable. Here, Section 73 says opposed to public policy, so it is hit by that. So the question thing is that outside the employment, this enforceability of contracts is all hit by Section 23 as well as Section 27 of the Indian Contract Act. Now, as back as 1980, the Supreme Court in the case of Superintendent Company of India versus Krishnan Murgai had held that a service condition or obligation cannot be extended after termination of service. It says every member of the community is entitled to carry on any trade, business, occupation to his choice. Nobody can stop it because it is against the Constitution of India, number one, and against the Section 27, this is opposed to public policy because you can't bind them because it is against the public policy of the company, violates the provisions of the Constitution of India. Hence, outside the employment, this contract is void and you cannot do anything on this. Then similarly, in the case of Ambience India Private Limited versus Naveen Jain, Delhi High Court has held the agreement between the parties prohibiting an employee for 2 years from taking employment in any present or past prospective customer complaint was held to be valid and void and contrary to Section 27 of the Indian Contract Act. They held a stipulation would prima facie against the public policy of India, and it is an arm twisting tactic adopted by the employer against the young man who is looking for a job. See, to that extent they have said that we can't do anything on that. See, and this is a very famous case between Pepsi and Cola. Between Pepsi and Cola, there are a lot of, you know that both are rivals in the trade and business. Both are. They compete in each and every aspect for capturing higher market share. Here also, the question came that enforcement of post-employment contract to restrain or restrict the freedom of an employee to obtain different job opportunities was held to be unenforceable and void. Here, they sought an injunction to be granted against this. But the court said no, it is not possible because it is hit by the Section 27, it is a violation and you are not entitled for any kind of injunction and we decline it. So they did not do it. So it means that anybody is free to take up any employment, wherever he wants to go, he can definitely go. That's the position of law. Then this is another important long landmarking case, American Express versus Priya Malik. Priya Malik was a very senior executive in American Express. She was handling almost many of the business segments of the bank when she was working. She was in a position naturally on account of her position being held. She was accessible to a lot of confidential information of many clients, customers, etc. Everything she had. And when she wanted to leave and take up employment, American Express filed a suit against her. They wanted to bring an injunction against her, restraining her from joining another competitor. Then the Delhi High Court clearly said it's not possible no relief can be given because such restriction, what you agreed here, is hit by Section 27 of the Contract Act, hence injunction cannot be granted. So she is free to do anything, whatever she would like to. Then here, another peculiar case here. Two companies, they enter into agreement each other, that is Escorts manufacturing versus Gokak manufacturing. They enter into mutual agreements. Both of them agreed that we will not hire anybody from your company who had been employment under company for 5 years without the consent of other company. So both companies joined together and made an understanding. And this case before even up to the Supreme Court, and Supreme Court said nothing to it. He said that this agreement is totally void because negative covenants operating during period of contract of employment and the employees are bound to serve as employer exclusively are generally not regarded as restraint thereafter do not fall under Section 25 of the Contract Act. Hence, this agreement is not valid. Then here, look at this case. This is very, very interesting case in sense. Percept Mark India Private Limited versus Zahir Khan. Here the court invited the attention of a case decided in 1874 in the case of Madhu Chandar versus Rajkumar Das, judgment of Sir Richard Couch. See, look here. The Contract Act came into force in 1982. In 1974 itself, this particular case came about the validity of Section 27. Even at that time, 136 years back, according to these people, the courts even that said that this is a restrictive clause in Section 27. It means that you can't restrict anybody from taking any employment, trade or business of his choice. So it is hit by that. They quoted this case, in this case, they said that interpretation of restraint of trade during post-contractual period, which interpretation has been uniform, consistent, unchanged for several years, and same thing will hold good now. So this is ruled out by Supreme Court in the year 2006, and they quoted this case of 130-year-old interpretation. Then in case of Wipro versus Beckman Coulter International, Delhi, here also they mentioned saying that a covenants between employer and employee contracts pertain to the period of post-termination and restricting employee's right to seek employment or to do business in the same field as the employer will be, the contract will be void. No employee can be confronted with a situation where he has to either work for the present employer or to be forced to idleness. Nobody can force it. Here in this case, Karnataka High Court, in the case of V.V. Shivaram versus Fiasco India Ltd. in 2005, it has given a favorable judgment. Here what happened? One of the person here, they were making a product patented by Turbostop, a particular component. This person, after he left the company, then he started manufacturing the same item, everything absolutely identical in all aspects of Turbostop. Then the management of Fisco, they contended that this is highly damaging because he is violating our own contract, that he has to be restrained. And it is not a violation of Section 27 because this is a thing about absolutely copying our own secrets. Not only the products, they also absolutely identical of what we are selling in the market. Then here the court restrained him. It means that they given injunction and said you can't do this. So this is the only case where exceptional case, depending on. So it means the thing is that the court will consider the case under exceptional circumstances of restraining, not otherwise. So this must be borne in mind. Then in the case of Polaris Software case, this happened in Madras. Polaris Software case was Suren Kiwadkar. Here also they wanted to restrain Suren Kiwadkar from making a press conference and holding a press conference and making public certain things against the police software. The court did not give injunction because outside the employment, so it will not, it is hit by section 27, it cannot be done. Similarly, financial software services systems versus Budasa in Calcutta High Court of Madras has said, the conduct of applicant or plaintiff appealing the court or appealing order of injunction restraint is different from giving any confidence to any third party or any adverse publicity to the media is not appreciable. The injunction was refused by the High Court, and however they said if you want you can claim damages, but we will not give any kind of injunction on this. Then the latest case was in case of division bench in Madras High Court, in the case of R. Babu versus TTK LKG, they set aside the order of learned judge who granted the injunction against an employee from taking up as manager in another company. The High Court held that the proposition of law is that a negative covenant restraining an employee from taking up employment with other establishment is violated section 27. They said no, it's not possible. Similarly, a cases in the VIS of Global Services Supreme, Bombay High Court did the same thing. In case of Star India versus Lakshmi Raj in Bombay High Court, the High Court also held the same thing. You can't restrict, you have to look for, if an employee finds a better position, better employment, better remuneration, for instance, he cannot be tied down on a clause of his own agreement. It's not acceptable. In Sangha Organic Chemicals United, same thing happened. An employee could not be constrained for all time to come use knowledge and experience he gained during the course of employment. A service covenant extended beyond the termination is absolutely void. Yeah, now we come to non-solicitation agreements. It has been held that non-solicitation agreements do not hit by section 27 of the Act, because here there are no restrictions on the trade, occupation or business. Hence, section 27 is not hit by this. Because there is no infringement of rights of anyone taking up any employment with any employer, including a competitor. Such agreements are not against public policy. Hence, this agreement is not void. The remedy available to restrict on carrying on solicitation or canvass in favor against an employer, remedy is available. You can always approach for a remedy. Employer can claim damages also arising out of such solicitations, and the same, if quantified and acceptable by the court as reasonable, it can be granted. In the case of Independent News Service Private Limited versus Anurag Muskan in 2013, in a very latest case, the Delhi High Court has said that the respondent can be enjoined from restraining making any such or such in future during the period of 2 years from 31/12/2005 to any other employees of the petitioner. As regards the solicitation already made by the respondent in his advertisement petition, if it is possible to substantiate this against arbitration proceedings, would be entitled for compensatory for grant of damages. But now the respondents can be enjoined from or restrained from making any such solicitations for a period of 2 years from 31/12/2005 is granted. So now you can see here, it means in solicitation agreements, if the damage is there, yes, you can quantify, claim it, and the courts will grant if it is reasonable. And you can also seek injunction against this, because this is not hit by section 27 of the Act. So here the employees have just relief to certain extent on this case. Similarly, in the case of another case in Delhi High Court has held the same thing in Discount and Protest International versus Bapadia. They held that the injunction only restrains defendant from approaching plaintiffs, suppliers and customers for soliciting business, which is different direct competition with the business of the plaintiff. They said that okay, yes, he can be restrained, and because he cannot solicit against the company, and he is restrained for this. So this way, restraint is quite possible. So these are few 2-3 cases I cited against the non-solicitation clauses. So in non-solicitation clauses, it's very clear that if the damages is there, if you are able to make out the quantify the extent of damage, and if the court finds it reasonable, you can claim damages. And depending on situation, circumstances, you can also get injunction against such kind of solicitions. So here, reliefs are available, and the contracts of non-solicitation agreements is definitely enforceable under the law. Now, let's study the levy of penalties and liquidated damages for breach of contract. So this is an important segment of the employment contracts. The question is, the most pertinent question arises is that here, whether the employment agreement to claim damages as stipulated in the agreement is enforceable under the Act. The simple answer is yes. The only thing is, such enforceability of agreement with a negative component is valid legally enforceable if the parties agree with free consent, without force, coercion, undue influence, etc. mistake. A pre-estimated damage, it should be actually pre-estimated. If that is the case, you can claim it. But suppose the court finds that the so amount mentioned is unreasonable, then it can order a reasonable compensation depending on the particular case. Now here, a restrictive agreement, as I said already, it must be very reasonable and to control the damage of employer. Now for instance, we put a clause like this: if the restriction engaging any employer who is engaged similarly for a period of 10 years or more is held to be against public policy, then there cannot be any relief for this. On the other hand, under exceptional circumstances, if you say for 2 years, it can be held valid, because this should be used exclusively in certain cases. Exclusively. Supposing you engage a person and put him for a highly specialized training, and highly confidential training where the whole business or the product. So the restricted covenant must be very reasonable and to control the damage of the employer. Now for instance, if the restriction on engaging any employer, engage with any employer, an employee who is engaged for similar type of business, if you stipulate a contract saying that for a period of 10 years, specifying that you shall not take up any employment with competitor, then it's against public policy. On the other hand, if it is restricted to, let's say, for 2 years, could be a reasonable period, but the two, you need to, this is applicable for only for exceptional cases, highly exceptional cases where a person has been deputed fire training with very, very intense and confidential information and etc. Only for those cases, the two for a reasonable period, maybe it can be enforced. But it cannot be an omnibus. But normally what we do, what generally corporates do is that even for mass recruitment when we go, we tell the people to say that, okay, we'll take you as a trainee for 2 years, we'll impart training, after training is over, then you shall serve the company for a minimum of so and so period. If you don't serve the company for a period, you will be levied liquidated damages of specifying the amount or not specifying the amount. All these things will come. It means that you issue such kind of a contract of letters to everybody. It's the omnibus, though that's not enforceable in law. That cannot be. So this can be enforced only in exceptional, highly exceptional cases. That too for a small period. We have to be very careful and cautious about this. Then about the liquidated damages to be claimed must be actual and quantifiable. That is called liquidated damages. Let's say, for instance, you depute a person for training. So you know the expenses, what is going to be incurred for the training. So one should be able to really quantify and incorporate in the agreement. Then it's a predetermined damages. So this will be accepted by court provided it's found to be acceptable in all respects. The damages which we call it as, for instance, a threat or interpreted as terror. That is to say, we insert a clause, if you leave the services within the agreed period of 5 years, you shall pay 10 times the salary or 2 lakhs or whatever it is. See, this is a penalty in terror. It is not liquid damages. It is a penalty. This will be void. This court will not accept this. And if you still contend, if it is really you are able to make out a case, then you can get some reasonable compensation, but not beyond this. In the case of Madras High Court, also in the case of Nazir Birkar versus Marshall and Son in 2004, it has held that the proportionate compensation will be paid for dependent for the balance period of service. Now, for instance, we enter into agreement with a person to say that after the training is over, you shall work with the company for 2 years, and if you leave in between, you shall pay a compensation of, let us say, 4 lakhs. Right? Now, let us take up this case. Supposing he leaves the company after completing 1 month short of that 5 years, are you going to recover the entire money? Or suppose he works only for 1 month and leaves, are you going to claim the entire thing? So, it's not acceptable. So, what has to be reasonable is that it has to be in proportion to the number of months of service where he has not rendered the service. Somebody will say, for instance, a person has to work for 5 years. If he has worked for 3 years, well, 3 years is worked. So the balance 2 years only you are entitled for to claim damages. So that way it becomes reasonable and courts will take it. This exactly happened in the case of Madras High Court in Nazir Birkar case. Same thing happened. So balance is payable. Then in the case of Narendra Singh Motilal Johari, the Gujarat High Court also had the same thing, saying that the amount fixed in terrorism was highly unconscionable, unclear and one-sided, and we can award only a reasonable compensation. Here also they said that he is entitled to only reward a reasonable compensation, and the court actually awarded a very reasonable compensation, taking into entire thing. Then Supreme Court in the case of Fateh Chand versus Balachan Das in 1963, it held very clear. This section is clearly attempted to eliminate somewhat elaborate refinement made under the English common law in distinguishing between stipulations providing payment of liquid damages and stipulation by way of penalty. Under common law, the Julian pre-estimate damages by mutual agreement as regarded as a genuine pre-estimate damages by mutual consent. The stipulation in the contract is a penalty. Then court refused to enforce it, awarding the agreed party only a reasonable compensation, not beyond that. So we need to bear it in mind, all these factors, when we really draft the agreement or try to enforce such kind of agreement or implement it. In the case of Chunalal Mehta versus Century Spinning, Supreme Court also held that here also they said that liquidated damages has to be highly reasonable, and you can't claim the specified amount what is the agreement, then you go by the sum specifically instead of money somewhat not ascertained or not ascertained on it there. You see, the agreement, there are two things for it. See, one thing, once we say that you are supposed to pay liquidated damage of so and so, so and so and so. At the same contract, we also say the management also, the employer also shall be at liberty to levy damages arising out of loss in business, etc., and all that. The second portion comes as unliquidated damages. The unliquidated damages can be claimed provided it is found to be reasonable, or not beyond this. But the first portion of it, that's a liquid damages, if it is found reasonable, mutually acceptable, that can be enforced. So in one single case, you may have two claims. One is liquid damages, another can be unliquidated damages. Liquid damages is mutually accepted and agreed, yes, probably will win. But unliquidated damages, it is purely, if the court finds reasonable, they will grant it. If it is not reasonable, you will not get relief. Similarly, in case of Mahadev Prasad or Siemens in Calcutta High Court, here also reiterated the same principle in this case also. Then in the case of Division Bench of Rajasthan High Court in the year 1955, held the same thing. They, of course, they quoted the same cases what we discussed. It's a Privy Council, Bhaipanna Singh case, and also Habib Ayub case, and also Mahale Prasad versus Siemens India, and they also said same thing. Some agreed or named agreement payable by breach thereof, the prime cannot be entitled to the entire sum as simple as that. That is merely because the sum has been mentioned in the agreement is so well. He is entitled for reasonable common subject amount named him, there being maximum is the what is stipulated in the contract. Now liquid damages. What do you mean by liquid damages? It's a fair, genuine pre-estimate of the probable loss that might cause as a result of breach, if it takes place. The essence of liquid damages is genuine pre-estimate of damages. I gave the example of already earlier. A person who is debit fraud, you definitely can quantify the amount of money what you are going to spend, and if you are not going to serve, you definitely know what is the amount of money suffer you are going to suffer. So that is called liquid damages, and that is definitely a point which can be claimed upon. So on going through the whole thing, the following is the intention of the legislation. It looks very clear. The company must prove that the damage is in the general sense. The contract with the parties estimating the damages in itself is evidence, because both parties discussed together. I said, okay, I pay this kind of a damage. But some named, however, not conclusive evidence. That is to say, if there is no evidence or circumstances showing that it was excessive, the court will not consider and they abide by it. If they feel that, okay, you have named certain liquid damages, and if the court comes to conclusion saying it is fine, they will accept it. On the other hand, if the other circumstances indicate that damages are equals to or may equal or likely to exceed the amount, the court also will abide by it. Where in other evidence so that it is unreasonable, the company will have to prove its damage irrespective of the figure. In the preparing this, I look at this slide. I have prepared a slide to show the difference between liquid damage and unliquid damage. The amount they pre-assess or is pre-estimated. Whereas in case of liquid damages, it is paid in cases of tort. It is a personal injury or loss caused to a person. If any person breaches his duty or causes any harm or loss to another person, it means it is a tortious liability and has arisen out of the person. So it is not a pre-estimated cases. It is assessed only after the injury or loss occurs. So normally the courts will decide that, and then based on the reasonableness they may award. Difference between unliquid damage and penalty. Unliquid damage, I have told you, is a fair. Liquid damage and penalty. What is the difference between liquid damage and penalty? As I said, all liquid damages is a pre-estimated damages, etc. I told you. Here also you can see in this slide the liquid damages. I will come to penalty. Penalty is the sum which is disproportionate to the damage likely to occur as a result of breach. Because the penalty, we incorporate the agreement without assessing the damage what is going to happen. We say pay 5 lakhs, we don't work. Pay 6 lakhs after you don't work. Or to pay 10 times the salary if you leave in between. So it means that we levy the penalty without assessing the damage. There is nothing but a penalty. So the essence of penalty is a payment of money stipulated in terror, as in terror. It's a terrifying person. It's a threatening that if you don't do this, this is a penalty. So the penalty is disproportionate to the damage, I told you already. The damage levied on the offending party is excess than the actual damage, then the is a punishment in nature. In such cases, the court can consider if everything is alright, it can only pay reasonable compensation. So it's for a company to show that some named in the agreement is a genuine estimate of damages or otherwise a reasonable compensation breach. So here, where a sum is named in the agreement as payable as breach thereof, the company cannot be entitled to entire sum named solicitor. That is, merely because the sum is mentioned, it does not mean that amount is payable. All the company would be entitled to a reasonable compensation subject to the amounts named therein being the maximum. What is reasonableness depends on facts and circumstances of the case. So here, the aforesaid result must hold good regardless of the consideration that the sum named in the agreement is under English law termed as liquidated damages or in nature of penalty that has to be decided, and that's why it is incorporated. Do a distinction between this and the only reasonable things are allowed. It must be for a company to prove the damage suffered by him by such proof that may directly or circumstantial and need not possess quality of arithmetical extension. If the company succeeds in establishing the sum named in the agreement is genuine pre-estimated damages, then it's fine. In deciding whether amount is fixed, genuine or pre-estimated or not, it will be a factor of consideration whether the sum named in the agreement is proportionate or disproportionate. The court will take into account. So, friends, gentlemen, the important thing here, these points should be borne in mind when we really draft such employment agreements and monitoring and enforcement. Otherwise, it becomes otherwise enforcement will be an issue.